At 3 o'clock in the morning, 6 police officers arrived at a house in Harris County, Texas. Inside, a 17-year-old was asleep in his own bedroom. An officer woke him with a flashlight. A few minutes later, he was in handcuffs, being walked out of his own front door, shoeless, wearing nothing but boxer shorts and a t-shirt. It was January. And here is the part that makes this a Supreme Court case. Those detectives had already decided they did not have enough evidence to arrest him. They came anyway. So, was that an arrest? Or was he a young man who agreed to come along and answer questions? The answer turns on one word he said in that bedroom. January 1999, a 14-year-old girl disappeared. Investigators learned she had been in a sexual relationship with her 19-year-old half-brother. They also learned that on the day she vanished, that half-brother had spent time with a friend. The friend was Robert Kaup. The opinion describes him as then 17 years old. Detectives brought both young men in and interviewed them. This next detail matters more than it looks. Kaup came to the station. He answered their questions. The record describes him as cooperative, and he was permitted to leave. He walked out of that building a free person. Hold on to that, because the same detectives are going to come back for him, and it will look nothing like this. Investigators asked both of them to sit for a polygraph, a lie detector test. A quick note on those, because television has done real damage here. Polygraph results are generally not admissible as evidence in court. They are an investigative tool, used to steer an investigation, not to prove a case to a jury. Kaup took one. He denied having anything to do with the disappearance. He passed. The half-brother took one. He failed. He took another. He failed that one too. On the third failed test, his story collapsed. He confessed. He said he had fatally stabbed his half-sister, and he said Robert Kaup had been involved. So, now detectives are holding a confession from one teenager that points directly at another one. Which raises the question every investigation runs into. Is an accusation by itself enough to arrest somebody? Because what those detectives had was one person's word. And that person had just admitted to a killing and had failed 3 lie detector tests before he said any of it. The trial court itself would later put the state of the evidence plainly in a finding the Supreme Court repeated. The detectives had no evidence and no motive to corroborate the brothers' allegations. No corroborating evidence, no motive offered. One accusation, standing completely alone. That is not nothing. Police are allowed to find an accusation suspicious and to want to talk to you. But there is a specific legal threshold for going further than talking, and it has a name. Probable cause. It means a reasonable basis to believe that a particular person committed a crime. It is not a formality. It is the thing the Fourth Amendment requires before police can arrest you. The difference between a suspicion and a seizure. The detectives in this case did not think they had it. And that is not my characterization of their thinking. It is in the record of the case. They did not apply for an arrest warrant because, in the opinion's own description, they did not believe they had probable cause for Kaup's arrest. The people investigating him had concluded themselves that they could not lawfully arrest him. But they still wanted him in an interrogation room, so they went looking for another door in. They went to the district attorney's office and asked for something called a pocket warrant. The opinion describes it as authority to take a person into custody for questioning. Custody says, without meeting the standard, you would need to actually arrest them. They tried to get one. They did not get one. The record does not say anyone turned them down, only that they tried and failed. And then, having failed to obtain the paper they went looking for, they drove to his house at 3 in the morning. 6 officers came, Detective Gregory Pinkins, 2 other plainclothes detectives, and 3 uniformed officers. Kaup's father answered the door and let them into the house. At least 3 of them walked back to the bedroom where the 17-year-old was sleeping. Keep those numbers separate because the court does. 6 at the house, at least 3 in his bedroom. Pinkins woke him with a flashlight, identified himself as a police officer, and said 6 words. We need to go and talk. Not, would you be willing to come with us? Not, you're free to say no. We need to go and talk. And Robert Kaup said 1 word back. Okay. That 1 word is why this case reached the Supreme Court of the United States. Because immediately after he said it, the officers handcuffed him. The order there matters enormously, and we will come back to it. They led him out of his house shoeless, dressed only in boxer shorts and a t-shirt, and put him in a patrol car. 17 years old, in handcuffs, in January, at 3 in the morning. They did not drive him straight to the station. They stopped for 5 or 10 minutes at the location where the girl's body had been found. And the opinion tells us why they stopped there, in anticipation of confronting Culp with the brother's confession. That was not a wrong turn. That was a tactic, questioning before the questioning formally began. Then they drove him to the sheriff's headquarters, took him inside, and removed the handcuffs. They put him in an interrogation room and read him his Miranda rights, the right to remain silent, the right to a lawyer. They told him the half-brother had confessed and had named him, and 10 or 15 minutes into the interrogation, Culp admitted having some part in the events. He did not acknowledge causing the fatal wound, and he did not confess to murder. He was indicted for murder regardless. A jury convicted him and assessed his punishment at 55 years. So, we arrive at the legal question. Was Robert Culp arrested at his bedroom door, or did he go voluntarily and get arrested later? That can sound like a question about etiquette. It is not. It decides whether the Fourth Amendment was ever switched on. Because the Fourth Amendment does not govern every conversation with a police officer. It governs searches and seizures. An officer can walk up to you on the street and ask you things. That by itself is not a seizure. You can decline, you can keep walking, you can close your door. A request you are genuinely free to refuse is just a request. It becomes a seizure at the point where a reasonable person in your position would no longer feel free to leave. And among the things courts look at are the threatening presence of several officers, physical touching of the person, and language or tone of voice suggesting that compliance might be compelled. That test was not invented for this case. The question was what it meant for a bedroom at 3 in the morning, with officers standing over the bed. The trial court refused to suppress the confession, and Culp was convicted. He appealed, and the 14th Court of Appeals of Texas agreed with the trial court. That court held that no arrest had occurred until after Culp confessed. Everything before that, in its view, was voluntary. And it pointed to the word, okay. He had said okay, so he had consented to go. That was the reasoning. Then the court addressed the handcuffs, and this sentence is worth hearing exactly as it was written. A reasonable person in Culp's position, the court wrote, would not believe that being put in handcuffs was a significant restriction on his freedom of movement. That is the court's own sentence. Handcuffs on a 17-year-old at 3 in the morning, not a significant restriction on his freedom of movement. Culp asked the Texas Court of Criminal Appeals, the highest court in Texas for criminal cases, to review that. It declined. So, he petitioned the Supreme Court of the United States. He filed as an indigent litigant, meaning he could not afford the ordinary filing costs. And the court did something that tells you how it saw this case. It did not schedule an oral argument. It granted review and decided the case in the same unsigned opinion, what lawyers call a per curiam. No justice signed it, and no separate opinion was filed by anyone. The opinion says the record shows, beyond cavil, that Culp was arrested. Beyond cavil is an old phrase, and a strong one. It means beyond any petty objection, beyond argument. A 17-year-old, woken at 3 in the morning by at least 3 officers, handcuffed, taken from his home, barely dressed, and driven away in a patrol car. The court found nothing in that resembling a consensual encounter, and it noted that the state did not even claim to have had probable cause. Which brings us to the part that most retellings of this case get wrong. They did read him his rights. That genuinely happened. The warnings were given before he said anything incriminating. So why didn't that fix the problem? Because the problem did not start in the interrogation room. It started at the bedroom door, hours earlier. When a confession is obtained by exploiting an unlawful arrest, the law treats it as connected to that illegality. It does not stand on its own just because it came later. Miranda warnings are one factor a court weighs in deciding whether that connection was broken. They are not a reset button. The court weighed how little time had passed, whether anything meaningful happened in between, and how purposeful the police conduct had been. Only the warnings favored the state, and the state, the court pointed out, had not even alleged any meaningful intervening event between the arrest and the confession. Now, here is what the Supreme Court did not do, because this is where the story usually gets told badly. It did not throw out the confession. It did not declare Robert Kaup innocent. It did not order him released, and it did not say anything at all about whether he committed the crime. It vacated the Texas judgment and sent the case back, giving the state one more chance to show the confession was a genuinely free choice, separate enough from the arrest to stand on its own. On remand, the state conceded that it could not point to anything that would carry that burden, and the appeals court sent the case back for a new trial. What happened to Robert Kaup after that is not what this case is remembered for, and it is not what it decided. It decided something narrower and more durable. Reading someone their rights does not unarrest them. If police take you somewhere you are not genuinely free to refuse, that is a seizure, and it requires probable cause, not a hunch, and not a piece of paper they could not get. The detectives here knew they did not have it. They went at 3 in the morning anyway, and it took the Supreme Court of the United States to say so.